FSSAI Act 2006, Chapter 8, Analysis of Food, Clause number 43. It empowers the Food Authority to recognize any food laboratory and research institutions as accredited by National Accreditation Board for Testing and Calibration Laboratories NABL or similar accreditation agency for the purpose of carrying out analysis of samples by the food analysts. Establish or recognize one or more referral food laboratory or laboratories to carry out the functions entrusted to the referral food laboratory. And this clause also frame regulations specifying the functions of food laboratory and referral food laboratory, the procedure for submission of samples of article of food to the laboratories for analysis of test. Clause 45 recognition 44 recognition of organization or agency for food safety audit is uh, is saying that the food authority can recognize one agency who can do food safety audit for different food business operator, whether the FBO is following proper food safety guidelines or not. Then clause 45 empowers the Commissioner of Food Safety of the state to appoint food analysts for such local area as may be assigned to them. However, no person who has any financial interest in the manufacture or sale of any article of food shall be appointed as a food analyst. A food analyst cannot be appointed if he has some uh, interest in promoting any food product. Then clause 46 enumerates the functions of food analyst. It provides that the food analyst shall cause to be analyzed such samples of article of food as may be sent to him or as may be sent to him by food safety officer. Food safety officer can send or by any other person authorized under the bill. A purchaser can also send the food sample after proper information to the FBO. Okay, and the food analyst shall prepare the report within 14 days of receival of the sample and send the test report to the designated officer. Any food business operator can make appeal against the report given by the food analyst to the designated officer, who shall refer the matter to the referral food laboratory as notified by the food authority for opinion. Next, clause number 47 sampling and analysis. It provides the procedure for sampling and analysis of articles of food. When a sample of any article of food or adulterant is taken, the food safety officer shall, by the immediately succeeding working day, send the sample in accordance with the rules prescribed for sampling to the food analyst for the area of concern. An article of food or adulterant seized, unless destroyed, shall be produced before the designated officer as soon as possible, and in any case not later than 7 days after the receipt of the report of the food analyst. Next, Chapter 9, Offences and Penalties. Section 48. It provides the general views that how a food can be unsafe, either by adding any article or substance to the food, using any article or substance as an ingredient in the preparation of the food, abstracting any constituents from the food, or subjecting the food to any other process or treatment. All these things, like if you are abstracting, if you are removing something from the food, or you are subjecting the food to any other process, any other further process, then it will be called unsafe. So, in determining whether any food is injurious to health, regard shall be taken that particular health sensitivities of a specific category of consumer, where the food is intended for the category of consumer, but also to the probable cumulative effect of food of substantially the same composition on the health of a person consuming it in ordinary क्वांटिटीज़. सो ये रिगार्ड लेना पड़ेगा कि एक जो खाना उस क्वांटिटी को खाने के बाद कितना हेल्थ इफेक्ट आया है, हेल्थ प्रॉब्लम आया है. ओके अगर वही खाना और किसी को भी दिया जाएगा तो कितना हेल्थ इफेक्ट आएगा, ऐसा वो रिगार्ड्स लेना पड़ेगा. देन फॉर द पर्पस ऑफ दिस पॉइंट, offences and penalties injuries includes any impairment, whether impairment means any defect, any problem, whether permanent or temporary and injurious to health, shall be constructed accordingly. कोई भी इंजुरी आया है अगर वो खाना खाने के बाद, then it will be a penalty will be there. And all this system is not applicable for primary food. Primary foods are those food which are just produced from the farmers. If this primary food is damaged or anything happened which is not happened due to any human being, then it will not be called as unsafe. Okay, this is section 48. Then 49, general provisions relating to penalty. So it provides that while adjudging the quantum of penalty, what should be the quantum? Quantum means what is the level of the penalty the adjudicating officer or the tribunal, as the case may be, shall have due regards to the amount of gain or unfair advantage. क्या वो advantage मिला, unfair advantage, wherever quantifiable, made as a result of the contravention. क्या लॉस और क्या गेन मिला, sorry not loss, what gain or unfair advantage was achieved by doing these activities, that will result in the penalty level. Then the amount of loss caused to any person, that previous subclause was telling what amount of gain, but amount of gain to whom, to the producer, to the seller. But now subclause B is telling the amount of loss caused to any person as a result of the contravention. The repetitive nature of the contravention, whether the contravention is willful, and any other relevant factors, all these things will be considered. Then section 50, penalty for selling food not of the nature or substance or quality demanded. अगर कोई खाना जिस क्वालिटी का डिमांड किया गया है उससे नहीं हुआ है, then what should be the penalty? So it provides that any person who sells to the purchasers prejudice any food which is not in compliance with the provisions of this act and the regulation made thereunder of the nature or substance or quality demanded by the purchaser, shall be liable to a penalty not exceeding 5 लाख रुपीस। अगर कंज्यूमर का डिमांड हुआ है इस टाइप का क्वालिटी का एंड द सेलर हैज़ गिवन समथिंग डिफरेंट, देन देयर विल बी ए पेनल्टी नॉट एक्सीडिंग अप टू 5 lakhs rupees will be penalty. However, the persons covered under clause 31(2) of this bill shall for such non-compliance be liable to a penalty not exceeding of rupees 25,000 rupees. Okay, then section 51 provides penalty for manufacturing, selling, storing or import etc. of substandard food for human consumption and makes it liable to a fine which may extend to 5 lakhs rupees. If you are manufacturing, selling or importing any substandard food for human consumption, that fine will be up to 5 lakhs rupees. Then section 52 for misbranded food. Any person who, whether by himself or by any other person on his behalf, manufactures for sale or stores or sells or distributes or imports any article of food for human consumption which is misbranded. If you are involved in any chain of the food, then you will be penalized if you are selling misbranded products, and the liable to be penalty which may not extend up to 3 lakhs rupees. Misbranded product for 3 lakhs rupees penalty. Then penalty for misleading advertisement. So it provides penalty for misleading advertisement and makes it liable to a fine which may extend up to 10 lakhs rupees. 10 lakhs rupees will be the penalty. Suppose you have made any false claim during your advertisement, you are promoting your product and you will say that this product will cure this disease, this product will increase your height, and then there will be a penalty of 10 lakh rupees if the claims, the health claims you are making is false, without having any base, without having any research, then up to 10 lakhs rupees of penalty is involved. Then penalty for food containing extraneous matter. In that case, if you are if you are making food which is having extraneous matter, or if you are import of such foods, if you are doing any imports of such foods and makes it liable to a fine which may extend up to 1 lakh rupees. How much? 1 lakh rupees will be there for what? Food with extraneous matter. Then section 55 provides that if a food business operator or importer without any reasonable ground fails to comply with the requirements of the bill or the rules, regulations or orders issued thereunder as directed by the food safety officer, he shall be liable to a penalty which may extend up to 2 lakhs rupees. Knowingly, if you are becoming a defaulter about the rules and regulations of this act, then there will be a fine up to 2 lakhs rupees. Then penalty for unhygienic or unsanitary processing or manufacturing of food. It section 56 provides penalty for unhygienic or unsanitary processing or manufacturing of food and makes it liable to a fine which may extend up to 1 lakh rupees. Same 1 lakh rupees penalty will be there. Then clause 57, penalty for possessing adulterants. If in your premises, if your manufacturing areas is having adulterants, then there will be a fine for up to 2 lakhs rupees if the adulterants is not injurious to health.
And if the adulterance is injurious to health, then there will be a penalty up to 10 lakhs rupees, up to 10 lakhs rupees. Okay. Then section 58, if the contraventions for which no specific penalty is provided, then there will be a penalty for 2 lakhs of rupees, for which there is no in this act. Suppose any penalty is given which is not written in the act, then that penalty will be up to 2 lakhs rupees. Then punishment for unsafe food, it 59(6) to provides punishment for unsafe food and makes the offence punishable where such failure or contravention does not result in injury with imprisonment for a term which may extend to 6 months and also with fine which may extend to 1 lakh rupees. Results in a non-grievous injury. If you are selling any unsafe food which results in a non-grievous injury with imprisonment for a term which may extend to 1 year and also with fine which may extend to 3 lakhs rupees. Then if unsafe food is sold and results in a grievous injury with imprisonment for a term which may extend to 6 years and also with fine which may extend to 5 lakhs rupees. And if you are selling the food at each unsafe, then it results in death of the person who has taken the food, then the imprisonment for a term which shall not be less than 7 years but which may extend to imprisonment for life and also with fine which shall not be less than 10 lakhs of rupees. Then clause 66 to provide punishment for interfering with seized items and makes the offence punishable with imprisonment for a term which may extend to 6 months and also with fine which may extend to 2 lakhs rupees. Suppose the food safety officer has seized the food article which is unsafe for the public health, and the supplier or the producer or the person who has produced that article has interfering the seized article, anyone who is interfering with the seized article, then there will be an punishable offence with imprisonment for a term which may extend up to 6 months and also with fine which may extend up to 2 lakhs rupees. Okay, it will be up to 2 lakhs rupees. Then section 61(6) to provide punishment for false information and producing any document by a person in connection with a requirement or direction under the bill, knowing it to be false or misleading, and makes him punishable with imprisonment for a term which may extend to 3 months and also with fine which may extend up to 2 lakhs rupees. Any misinformation communicated, then there will be imprisonment up to 3 months and 2 lakhs rupees of punishment fine. Then 62, punishment for section 62, punishment for obstructing food safety officer, or if you are impersonating the food safety officer, then there will be a punishment of imprisonment of 3 months and also 1 lakh rupees of fine. If the food safety officer is obstructed, if he is denied to do his act as per the bill, as per the food safety act, then there will be a punishable imprisonment for a term of 3 months and 1 lakhs of fine. Then section 63, punishment for carrying out business without any license. If a food business operator is making, selling, storing or distributing or importing any article of food without a license, under the clause 31 2, sorry, not 31 2, under this clause 62, then any person or a food business operator except the persons exempted from licensing under the clause 31 2 of the bill, that we have discussed, that primary consumer, either himself or by any person on his behalf who is required to obtain license under the bill, and makes him punishable with imprisonment for a term which may extend up to 6 months and also with a fine which may extend to 5 lakh rupees. So without license you cannot do any kind of business except the primary producer of the food, okay, and that fine will be up to 6 months of imprisonment and a fine which may extend up to 5 lakh rupees. Then section 64 seeks to provide punishment for subsequent offences and makes the offender liable to twice the punishment which might have been imposed on a first conviction. So if you are doing the offences repeatedly, then in that case what will be the quantum of offences, that is discussed in section 64. Okay, then 65, compensation in case of injury or death of consumer. So if you have provided the food which has made the person death, if that consumer is died, then in case of that, what will happen? Then offender is liable to pay compensation to the victim. The offender, the food business operator is an offender, and that person has to pay the compensation to the victim or the legal representative of the victim is sum not less than 5 lakh rupees in case of death, and sum not exceeding 3 lakhs rupees in case of grievous injury, and a sum not exceeding 1 lakh rupees in all other cases of injury. Okay. Then section 66, offences by companies. Company means any body, corporate, and includes a firm or other association of individuals, and its director in relation to a firm means a partner in the firm. So this section of says about the offences by companies. So if the company has done any offences, any problem with the public health, then the companies in charge will be punishable about the offences. And if the company has many branches, then the concerned branch head or in charge of the food safety will be liable to be punished. Then section 67, penalty for contravention of provisions of this act in case of import of article of food to be in addition to penalties provided under any other act. So in this section, if a person is importing the article which is not complying with the act, then he will be penalized with the provisions given under FTDR, Food Trade Development and Regulation Act 1992, section 22 of 1992, and the Custom Act 1962, that is section 52 of 1962, be also liable under the act and shall be processed against accordingly. and any such article of food shall be destroyed. That food should be destroyed or can be returned to the importer if permitted by the competent authority under the FTTDR Act and the Custom Act 1962 or any other act as the case may be. Next chapter, section 16, adjudication. In this, state government will employ one officer not below the rank of additional district magistrate of the district where the alleged offence is committed. One officer will be there who will be appointed as additional district magistrate for that district where the offence is committed. Then power to compound offences. This section says that no offence for which punishment or imprisonment has been prescribed under this act shall be compounded. Means after doing that offence you cannot compound that offence repeatedly. Then section 70, establishment of food safety appellate tribunal will be appointed, and this appellate tribunal will deal with all those offences, penalty discussions, what will be the punishment, all these things. Then procedures and powers of tribunals. In this case the powers of tribunal is there where the civil court will not interfere. Then civil court not have jurisdictions. That section 70 is telling that this act, suppose one person has committed any offences related to this act, then civil court has no right to do the jurisdictions, adjudications. Okay. Then power of court to try cases summarily. It is possible for the court to deal at summary basis, he can do. Then special court and public prosecutor may be designed to deal with these offences. Section 75, power to transfer cases to regular courts. Yes, the power can be transferred to the regular courts if the case has gone beyond the limit. Means, so if the offences is not triable in the special court, then there is the power to transfer cases to regular court. Then appeal. One person can appeal the judgment and he can goes to high court. Then time limits for prosecutions. There is a specified time limit for prosecutions, and this section says that no court shall take cognizance of an offence under the bill after the expiry of the period of 1 year. There is 1 year time limit for prosecutions. Then power of court to implead manufacturer, etc. Then section 78 then says what? Power of court to implead manufacturers. Implead means proceed against the manufacturers if the manufacturer or producer has done against the law. Then magistrate power to impose enhanced punishment. There is there 79. Then 80, defense which may or may not be allowed in prosecution under this act. Defense which may or may not be allowed in prosecution under this act. So defense is some cases defense is allowed and some cases defense is not allowed. That is mentioned in section 80. Then chapter 11, finance and accounts, audit and reports. Okay, this section is not much important for us. That food authority has some budget, finance of the food authority, accounts and audit of food authority, annual reports of food authority, all these things are mentioned in 81 to 84 section. Then chapter 12, power of central government to issue directions to food authorities and obtain reports and returns. In this section 85, regarding the policy, anything, central government has the power to give the directions to the food authorities. He can ask any questions about any policy, all those things. Then power of central government to give direction to state governments is there regarding food safety, all those things. He can give the direction to state authority. Then members, officers of food authority and commissioners of food safety to be public servants, all these things are there in 87. Then protection of action taken in good faith for 88. Then here all these sections are there. My voice is not proper, so I am not dealing with all the sections. You can make a pause and discuss little bit about it. Thank you a lot.